everyone, this is April, patent attorney here, and in this video, we're going to be covering an intellectual property filing strategy that makes a distinction between why you should file a provisional patent application over a non-provisional one. Okay, so let's dig in. I've got 3 points here for you. All right, my first point is, what is the definition? What are the distinctions between a provisional patent application as opposed to a non-provisional one? Well, by definition, provisional means something that can be changed in the future. It can be altered. And non-provisional means the opposite of that. You cannot change it. So basically what that is saying is that whatever you file as an innovative concept at the USPTO, it cannot change when you're going through a non-provisional, if you're filing a non-provisional patent application. If you file a provisional patent application, that means that in the future, within 12 months, you possibly could add to it. You might alter the scope of your innovative concept. Whatever the case may be, the provisional only basically it saves the date for that innovative concept. And now, as you know, that with the American Invents Act, it is no longer first to invent, it's first to file. So you've got to file swiftly as soon as innovation hits you. Go ahead, hire an attorney, get your provisional patent application drafted or a non-provisional one drafted. And so that's the definitions. Point two is the content. Well, what's the difference between the content of a provisional patent application as opposed to a non-provisional one? Well, let's start with the non-provisional patent application. Non-provisional patent application includes a specification. The specification includes a set of claims. The claims are basically sentences that are likened unto a deed that define the words of a deed that define the real estate for a particular property. Well, the claims define the intellectual property of your innovative concept in words, okay? And so we'll go over that in the future. So you've got your specification that includes a set of claims. And then you have to file an oath and declaration that is signed by each inventor. And it basically states that I swear, I'm telling the truth, that this is my innovation. I came up with this idea. And then you also must file an information disclosure statement, which states, here are the patent references that we knew of. This is the prior art that we knew of, we had knowledge of. Again, for non-provisional, you must file the specification, including a set of claims, also drawings if you have drawings for your innovative concept, and an oath and declaration and an information disclosure statement or an IDS. But for a provisional patent application, however, must include just the specification. It does not need to have claims, not even one. You do not have to file an IDS. You do not have to file an oath or declaration. That's the content. Now, going back to the specification typically includes a background, summary, brief description of the drawings, detailed description of the drawings, a set of claims, and the drawings, the figures. So that is point two, the content. Now for point three, the intellectual property strategy employed typically as it relates to a non-provisional versus a provisional. Typically with a provisional patent application, people file that when they're unsure of the market. What's the demand for this particular product that is related to this innovative concept? Is it worth my time and energy and finances to fully flesh out and go through the examination process of filing a patent application? Sometimes people file a provisional patent application because say they have a technical conference that they want to speak at, some type of speaking engagement, or they want to publish a paper in a technical journal. When you do that kind of thing, you need to, before you do that, you must file. It's best to file or you're going to lose. You have a certain period of time before, and it's a grace period, it's a 12-month grace period for when you have other people have knowledge of your innovative concept, or you propose to sell it, or you offer to sell it. So it's better just to go ahead and file it swiftly. And then also, because of the American Invents Act, the standard is for you to file it first, not first to invent, it's first to file. And so a lot of people now file a provisional swiftly, or they file a non-provisional one swiftly. Okay, and during that time, when you have that 12-month period, you can assess the marketability of your innovative concept or design, your products or services that relate to the innovation, and see whether it's worth your while. See if you could raise more money. And then for a non-provisional patent application, some people, they have the funds, they have the time, they have the resources to go forward with the patent, and they are more certain of the value between the non-provisional versus the provisional. A lot of times, if you're going before investors and you say, well, I have got provisional patents, that really means not much. It doesn't really show that you're very sure about the innovative concept and design. So the non-provisional patent application might give you a leg up when you go before angel investors or VCs and you say, well, we filed a non-provisional and this is the point where it is an examination or it has issued. We have a issued patent. So it's best to go ahead and file that non-provisional in those cases. All right, so I hope you have been inspired to go forward with your innovative concept. Keep on innovating and protect your domain. You can reach out to me, leave me a comment below if you have any questions about this video, or you can look me up under Monarch Intellectual Property Group. Possibly I can help you with the filing of your provisional or your non-provisional, and I'll try to work with your budget. Also, if you are not sure about whether you want to hire an attorney, you can always buy a copy of my book. Check out a copy. It's on Amazon. It's also on my website, Secrets of a Patent Attorney, or it might be on monarch-law.com. It basically shows you teaches you how to draft your patent application from beginning to end, and also to file your patent application electronically. Okay, so that's all. You have a great day. Keep on innovating. Bye. If you like this video teaching, please subscribe below and give us a like. Thank you. Also, please note, the material presented herein is for informational, educational, and promotional purposes only. The federal law of the United States is constantly changing. There is no guarantee that all of the relevant changes have been noted herein. As such, this video should not be intended or taken as legal advice. Neither does it establish an attorney-client relationship. Thank you.